Hi, this is Kelsey Fukowski for AP Gov Review, and in Chapter 3, Part 1, we're still in Unit 1 of Constitutional Underpinnings. We're going to talk about a major concept here that's going to undoubtedly appear in some form, whether it's a few multiple choice questions or a part of an FRQ, and that's going to be dealing with federalism. And federalism, really, it's important to note that really it's a sharing of power between the central government or the national government and state and local governments. And there are sort of a few models to go over, as part of the federal system. You have one that's called the unitary system, where power derives from the central government and is given to the states as well as the citizens. Notice it is a top-down approach, and this would be similar to what you see in the UK or France. You don't necessarily need to concern yourself so much for the AP Gov because it's just on the American system. Just keep that in mind. Another model that really has only been in existence once has been the United States' first constitution under the Articles of Confederation, where you had power actually flowing from the state or local governments to the citizens as well as the central government. So power typically tends to flow from central governments. In this case, as we know, under our first constitution, came from the state and local governments. That's where you found the bulk of the sovereignty there. In our current system today, power is divided between the central government or the national government and state and local governments. And you see that there's this sharing of power, and both the government and the constituent governments, that being again the state or local government, is acting directly upon the citizens. And both, for any type of change in our constitution, will have to approve it. So the national government can't just act however it wants. If it wants to amend the constitution, the state and local government has to have some say as well. And we see this, of course, in the United States, and another good example of this is in Canada. And so why federalism is so important is it decentralizes our politics. It allows more people to participate in government. If you look at the number of local governments in the United States, there are tens of thousands, whether you want to run for town council, if you want to become the mayor of your township or city. So it allows more people to participate in some fashion because, again, you're sharing power. Keep that in mind. It's so important that you're sharing power between the state and local governments with the national government. It also will decentralize our policies. Really, the states can act as laboratories. So if there's a problem, you can have California try something. And if that works out really well, maybe other states will adopt it as well. So that's important to keep in mind too. So states can solve the same problem in different ways. And then, you see some states being policy innovators. Sometimes it works out really well, other times it really doesn't. So again, states can act as laboratories, and that's really a hallmark of federalism. We're going to continue into part 2. And really where we see the constitutional basis for federalism comes out of the Supremacy Clause in Article 6 of the Constitution, which essentially states that the Constitution is the supreme law of the land. And if you notice that here you have the Constitution, and what comes after that are acts of Congress or laws of Congress along with treaties, state constitutions, state laws, statutes, and city and county ordinances. So this is the hierarchy that you see here. But keep in mind that at the same time, the national government has specific powers it cannot take from the states, and that comes out of the 10th Amendment. Really know the 10th Amendment is the basis for federalism, as it guarantees that any power not given to the national government is automatically reserved to the states. And we see that in the forms of, for example, driver licenses, speed limits, education. Those are all typically state powers. And here are some powers granted to the national government by the Constitution. For example, coining money, declaring war, establishing post offices. Some powers denied by the Constitution for the national government. Well, they can't violate the Bill of Rights. They can't change state boundaries. And then you have shared powers between the national and state governments. For example, taxing. Your state might be one, for example, New Jersey has an income tax, and then you also pay a national income tax. So those are shared powers right there. Also, you have state courts, you also have national courts. Good example right there. So you see some overlap. Whereas some powers are denied by the Constitution for both the state and the national government. Can't grant titles of nobility. Take the 13th Amendment, can't permit slavery. And then you have, for the state government, they have specific rights. They can establish local governments, they can conduct elections, ratifying amendments to the federal constitution, And then you also have some powers denied specifically to the states. For example, coining money or taxing imports. They cannot do that as that is a national power. So again, you're sharing power as this Venn diagram is showing, but you also have some powers delegated just to the state or just to the national government. Now, continuing on, we've seen over time, this is an important concept to know, that the national power of the government has increased both with implied and enumerated powers. Really where we see the strength of the government increasing significantly really starts in the early 1800s. One of the more famous Supreme Court cases is McCulloch v. Maryland, where the state of Maryland is trying to tax the national bank. And via the Elastic Clause is that Congress can do anything it deems necessary and proper. And keep that in mind. What is necessary and proper? Those are two very ambiguous words. And through the Elastic Clause, it has allowed the national government to expand significantly. And we'll see that also when we get into Unit 6 with civil rights and civil liberties. Commerce Clause, Gibbons v. Ogden, where basically the ruling stated that only the national government can regulate commerce, not states. So keep that in mind. Everything that's, there have been many ways in which the national government has used the Commerce Clause to expand its power. For example, you have the FAA, which regulates airlines. Why does the national government get to do that? Well, it crosses state boundaries. So the Commerce Clause, along with the Elastic Clause, two major clauses, very much increasing the power of the national government. Also, through the Civil War, you see this war mainly being fought over the federal government is supreme. States cannot nullify or secede for any reason. And that just significantly is going to bolster its power as well. And then, as I mentioned earlier, in Unit 6, we're going to really see how the civil rights movement is also going to bolster the power of the national government in Brown v. Board of Education. I wouldn't really worry about that particular case in Unit 1. Certainly that's something you're going to want to focus on when you get into Unit 6. And then over time, as the national government's power is increasing, you are going to see the erosion of state power. Now, something I just want to mention quickly, and again, some of this overlaps with Unit 6. I know I've been repeating that many times, but something called the Selective Incorporation, where the Bill of Rights was meant to only apply to the federal government and not to any state government. Really just be mindful that starting in the 1920s, you have what's called selective incorporation, in which the portions of the Bill of Rights, for example, freedom of speech, are going to then slowly but surely apply to the states as well. Because remember, the Bill of Rights was to protect the people from the federal government, not necessarily the states. So ultimately, over time, you're going to see through selective incorporation that the Bill of Rights is going to apply to the state level as well. And again, just to mention these Supreme Court cases in terms of impacting federal and state regulations, right? We have McCulloch v. Maryland. We have Gibbons v. Ogden with the Commerce Clause. I wouldn't really worry about this particular case. I do want to mention, though, U.S. v. Lopez. That was actually a blow to the national government because they were using the Commerce Clause to regulate everything, including the sale of firearms within a school zone, and they tried to pass that using the Commerce Clause. And that was where the Supreme Court said, you know what, you went a little too far. The Commerce Clause does not apply here. So this was actually a win for states. So you have, certainly with Supreme Court cases, you have federal and state relations being impacted all the time. So keep that in mind. Now, with federalism, you have obligations amongst the states to one another. For example, the full faith and credit clause, that each state must recognize official documents and judgments rendered by other states. So, for example, if you get married in California and then you move to New Jersey has to recognize that marriage. And really where we see the state obligations to each other comes out of Article 4 of the Constitution. It also is going to include the Privileges and Immunities Clause, in which citizens of each state have privileges of citizens of other states. So just because you're from California, New York, and you're visiting New York can't treat you any differently, that your rights just don't go out the window. So they have to respect those rights as well. Also, in terms of extradition, should you commit murder and flee to another state and get caught, that state has to return you to the state in which you committed that criminal act. So you have extradition all the time, and that's an obligation between the state. So when we look at intergovernmental relations, Prior to the 1930s, we had a concept known as dual federalism, in which the government in both the states and the national government remained supreme within their own spheres. So really the powers given to the national government remained exclusive to them, and the powers for the state remained exclusive just to the state. There was no overlap. There was no real sharing of powers by any means. And again, they were acting in their own separate spheres. So keep that in mind. It's almost like a layered cake that you had no intersection, you had no overlap between the national and the state government. Really, you see this ending in the 1930s following the Great Depression, and you have something that comes about known as cooperative federalism, in which the powers and policy assignments became really overlapped between the state and the national government, more like a marble cake, if you will. We see this in terms of shared costs in administration, states following more federal guidelines. So a good example to, again, illustrate this is really where you look at dual federalism. It's more of a layer cake. So this might be the federal government, this is the state government power, there's another federal government power, right? There's no mixture here. And then after the 1930s, you begin to see sort of the national and the state governments work together, or cooperative federalism, as they're sort of more intertwined, as you see more programs. For example, Medicare, Medicaid is going to eventually occur, and you have the national government giving money and sponsoring those programs, but they're also being implemented at the state level as well. So prior to the 1930s, federal and state governments acted really separately. After the 1930s, they're now working together, as illustrated by the marble cake. Okay, let's finish up with a review question, and take a moment, pause it, and look at this, and then I will reveal the answer. All right, so of the following, which has been used most to expand the power of the national government? If you said the Commerce Clause of the Constitution, you would be correct. Remember, though, there was that limitation in U.S. v. Lopez, but certainly the Commerce Clause has certainly given the national government a lot of power. And if you can remember that Supreme Court case, Gibbons v. Ogden, you're even in better shape. Really, the amendments, you couldn't really say that's been used to help the national government, because in many ways, the Bill of Rights is the limitation of what the national government is allowed to do. So keep that in mind as well. So the best answer being Commerce Clause. All right, here's one more additional review question. The full faith and credit refers to the obligation of, take a moment to read through them, pause it if you need to, I'll reveal it momentarily. And if you selected choice B, states to honor public acts, records, and civil judicial procedures of every other state, you would be correct. That is the only good answer out of these 5.